Welcome to Legal Resources Radio, where we invite you into the world of social justice, advocacy, and public interest law. Throughout this podcast series, we'll share stories, insights, and expert advice from our dedicated team at the Legal Resources Center, as well as from our valued guests. In each episode, we'll dive into the legal landscape, tackle pressing social issues, and aim to empower you with the knowledge to make a difference. Whether you're a community activist, a legal professional, passionate about social justice, or just curious, this is the place for you. So wherever you are, washing dishes, at work, on the bus, train, or plane, or just relaxing at home, plug in your headphones, take a deep breath, and get ready to begin.
Hello, everyone, and welcome to the Legal Resources Radio's February podcast. This month, we're bringing to you a double header. So that means 2 episodes this month because we feel really bad that we didn't get anything to you in January. Things just got out of hand and we couldn't get anything to you. But this month, 2 podcasts. And the theme of this month's podcast is South Africa, a surveillance state, or maybe a state surveil. To kick us off and to round the topic off a little bit, on the extent of surveillance in South Africa, the tech of surveillance tech in South Africa, but also, to speak about the legal reform or the lack thereof of the intelligence and security sectors in South Africa, is a renowned academic, intellectual, and anti-capitalist activist, Professor Jane Duncan. She is currently a professor of digital society at the University of Glasgow's School of Social and Political Sciences. Previously, she was a professor at UJ and also head of department at UJ. And she's a co-founder of the Media Policy and Democracy Project here in South Africa. Her earlier work, however, started at the Freedom of Expression Institute, which eventually progressed into being a legal clinic that was offering legal services to persons that were suffering from abuses of their right to freedom of expression. Importantly, throughout her career, she has been an author of numerous books, chapters in books, and journal articles that spoke to this podcast's theme, specifically on issues of national security surveillance, surveillance capitalism, the right to protest, and the rise of a securocracy in South Africa. We're really excited to have her here today, and we hope that she can, bring some insight into the state of surveillance in South Africa for you. Hello, Professor Duncan. Thank you so much for joining us on Legal Resources Radio today. How are you doing?
I'm well, thanks, Kemal, and thank you very much for the invitation from LRC.
No, it's an absolute pleasure, and we couldn't think of anyone better to have you here on and to talk to us about the surveillance topic that we're doing this month on our podcast. And so I've kind of spoiled the theme already. So the theme of this podcast is surveillance technology and the regulation of it in the South African space. So after this podcast with you, I'm going to be talking to Murray Hunter specifically around facial recognition technology. He works for Alt Advisory here in South Africa, and he's going to talk to us about the emerging, existence of it within the surveillance context here in SA. And so within that context, I kind of wanted to ask you, or maybe to get a comment from you on the rise in surveillance technology in general in South Africa, and maybe the risks that you see it presenting to us in terms of human rights.
Well, I think there is a worldwide problem of expanding surveillance technologies because digitization has greatly enhanced the ability of governments and private actors to collect, store, and analyze our data at scale in circumstances that are often not entirely clear. And this is where the first problem comes in, that we are emitting data all the time. I think far more data than any of us ever realize. And this data isn't going to waste. It's being used and abused and exploited by private companies and governments as well, who are using it increasingly in order to track our movements on grounds that are often fairly unclear. And this is particularly the case when it comes to national security, because national security is notoriously secretive and difficult to define. And I think that governments have a vested interest in keeping the definition of national security as elastic as possible in order to justify scooping up huge quantities of data into the dragnet. And boy, is there a lot of data to scoop up.
I think that's primarily why the Legal Resources Center has jumped into this space. It seems that tech is, advancing so quickly, and our law isn't necessarily following in behind. And there are a lot of issues with what we see that's happening online, whether it's social media, but also just in terms of the way we're being surveilled, not only with our data from social media, but then maybe sort of other sort of CCTV camera, that kind of cell phone data. And on that, I kind of wanted to talk to you specifically now in the beginning about a safe legislative and regulatory environment in South Africa with respect to surveillance. And I think the best place to start is the Regulation of Interception of Communications and Provision of Communication-Related Information Act 2002, famously known as RICA. And so I remember, I was still quite young, but I remember RICA being the thing that we had to do to our SIM cards when we were still I remember I used to be able to go to Pick and Pay and just buy a dummy SIM card. And then that stopped because now every time you bought a SIM card, you had to have it RICA'd. But I think it's probably, in relation to this topic around surveillance, it's probably a little bit more complicated than my dummy SIM card. So maybe can you talk to us a little bit about what that act did, but also what happened in the Ambubugani Center for Investigative Journalism versus the Minister of Justice case that was finally decided in 2021?
Yes, sure. Well, happily, we're having legislative amendments to RICA at the moment, but there's one crucial legislative amendment that isn't being attended to at the moment, which is shortening the name of RICA because it's extremely cumbersome and somebody needs to do something about it. But yes, we have a surveillance law, as you mentioned, that governs the circumstances under which people's communications can be surveilled. And RICA authorizes, it legalizes the interception of communication, but it also makes it unlawful to intercept communications without going through the process that has been set out by RICA. So this means, and it's a very positive aspect of RICA, that people can't surveil your communications willy-nilly. They have to follow the process. And RICA also spells out the state agencies that are responsible for intercepting communications. So there's a closed basket of state agencies that can actually use the RICA judge, which is positive. Another positive of RICA is that it requires judicial authorization of intercepts. One could query whether it's strictly judicial authorization, because actually the person who does the authorizing is a retired judge, a specially designated retired judge. There have been arguments about whether that person should be fully, a member of the legal system. But at least we have some manner of judicial authorization. We also have strict grounds on which communications can be surveilled. So you need to prove that there's a reasonable grounds to believe that a crime has been or will be or potentially may be committed, but you need to have compelling reasons to think that. And the surveilling of communications needs to be a method of an investigatory method of last resort as well. So I think all of these things are positive, and there's no doubt that a law such as RICA is needed. But we must think back to the context in when RICA was drafted and promulgated. It was actually drafted through a fairly lengthy and exhaustive law commission process, because it was meant to replace the Apartheid-era Interception of Communications Act. Apartheid era to an extent, because the Act was actually promulgated in 1992 as a stopgap measure to try and have a more human rights friendly approach towards communications surveillance after the deep, dark days of apartheid and the terrible human rights abuses that happened during that period. So we had the stopgap measure, we had the Law Commission inquiry into the matter, and a draft law was produced that quite a few people were very unhappy about because they felt that it didn't strike an appropriate balance between privacy and freedom of expression on the one hand and the need of the state to intercept communications on the other. So there was this lingering unhappiness, and the draft law went to parliamentary hearings, and there were also a lot of reservations that were raised about the fact that it wasn't privacy protective enough. But the law was being finalized in the wake of 9/11, and there was a global state of emergency, if one could put it like that, at that stage. And we saw the rushing through of a range of anti-terror laws. And RICA, although it was most of the work had been done before 9/11, really got swept up in all of that. And given the urgency of getting RICA onto the statute books, it was past flaws and all. However, those flaws have come back to bite us down the years, because the weaknesses in RICA and its privacy protections have been exposed for all to see. And they were exposed when information came to light during a court case involving a former President Jacob Zuma, that the communications of investigative journalist Sam Sol had been intercepted. It would appear in order to attempt to identify his sources of information in the National Prosecuting Authority. He was in a discussion with Billy Downer at that stage. And his phone conversations that had been recorded were extremely extensive and over a fairly long period of time. So, there was a huge amount of incidental data that was also collected in addition to the data that was supposedly of national security interest to the intelligence agencies. And this information came to light through this court case. It came out into the public domain, and Sam Sol, to his credit, decided to take up the issue not just as an individual issue, as a violation of his individual privacy rights, but he and the investigative journalism outfit that he works for, the Amabugani Center for Investigative Journalism, generalized the issue and turned it into a constitutional challenge to areas of weakness in RICA. So that is how the case eventually found its way into the Constitutional Court, the constitutional challenge.
And so let's continue with that. Let's talk about what were they challenging? What was it in RICA that specifically they found to have, unconstitutionality?
Fair enough. And perhaps we also need to sketch some of the context as well behind the court case, because
Yes.
the Edward Snowden revelations had just happened from 2013 onwards, exposing huge abuses on the part of the Five Eyes countries, with the US and the UK at its helm, of the bulk data capabilities of those particular countries. So in the wake of the Snowden revelations, there was a lot of work that was undertaken by civil society, and there was a rash of cases that went to different courts, including, importantly for our purposes, the European Court of Human Rights, where new privacy standards were set in the context of interception of communications. Also, there was a civil society standard, if you like, a gold standard, that was developed at that stage, known as the necessary and proportionate principles, or the international principles on the application of human rights to communication surveillance. So I think all of these new principles were brought to bear in the RICA case. And the first principle that was highlighted very, very prominently in the necessary and proportionate principles was post-surveillance notification. So in other words, if you have been the subject of surveillance by a state agency, within 90 days of the warrant, or in RICA terminology, the interception direction, having lapsed, you need to be notified of the fact that you were under surveillance. And this gives you an opportunity in order to contest the bases for surveillance and to defend your rights in court. So there was no post-surveillance notification that was in RICA at that stage, and increasingly post-surveillance notification had become a feature of surveillance laws internationally. And that the adoption of that measure picked up speed in the wake of the Snowden revelations. The second area of unconstitutionality that the Constitutional Court found was what they referred to as the ex parte problem. So in other words, when state intelligence agencies go to the RICA judge in order to request an interception direction, the judge only ever gets to hear their side of the story for why they want the interception direction. And they can cook a story, and they have cooked stories in the past. So if one thinks, for instance, of another case that came to light involving two former Sunday Times journalists, Stefans Brummer and Mzilikazi wa Afrika, it turned out that their communications had been intercepted on the basis of a lie. The judge had been told that apparently these were criminal suspects rather than being investigative journalists. So because state agencies can obtain interception directions purely on the basis of their own information, the judge can be lied to and has been lied to. So this comes from the fact that judges hear applications on an ex parte basis. So that was the second area of unconstitutionality that the Constitutional Court found, that ways need to be developed by the executive and then passed by the legislature in a new RICA law that would make the process more adversarial, to even out some of the structural unevenness between the intelligence agencies on the one hand and communication subjects on the other. The third area of unconstitutionality the court found was the non-independence of the judge, because the judge was being appointed by the Ministry of Justice on an annual basis, which created uncertainty around whether the judge was going to be appointed again. So there was insecurity of tenure, if you can put it like that, which could lead to a situation where the judge was not willing to be particularly adventurous in the decisions that they took in order to secure another term. And also for a judge to be appointed by a member of the executive could potentially make that judge beholden to the appointing authority. So all of that, the Constitutional Court found to be problematic. And they told the legislators to find a more independent way of appointing those judges. And then the third area of unconstitutionality, the fourth area of unconstitutionality related to the proper management of data. And there have been a set of standards that have been developed down the years, notably by the European Court of Human Rights, that I think have been referred to by many courts around the world, including the South African Constitutional Court, around the proper processing of data, including the proper management of data to ensure that it is processed in a transparent and accountable way. So RICA didn't really make it clear the circumstances under which data had been collected, whether only relevant data was being stored, whether the principle of expunging data that wasn't relevant to that particular case was being adhered to, who was having access to the data that was being stored, whether it was being stored securely, and the circumstances under which data was being expunged. So all of these things, the fact that there were no rules spelling out the proper management of data, predisposed the data that was being collected to abuse. And legislators were told to go off and do something about that. And then the fifth area of unconstitutionality related to the fact that the RICA judge was never tipped off by the intelligence agencies who were applying for interception directions that the surveillance subjects were journalists or lawyers. Now, journalists and lawyers are politically sensitive professions because they are particularly susceptible to being put under surveillance by people who find them politically inconvenient. And journalists need to protect their confidential sources of information and are unable to do so if their communications are intercepted arbitrarily, as was the case with the journalists who I've just mentioned. Lawyers need to be in a position to offer their clients professional privilege. And how do they do that if they also aren't assured that their communications will not be intercepted except under the most extraordinary circumstances that are clearly spelt out in law? And none of this applied in the case of RICA. And then the last area, which isn't strictly speaking an area of unconstitutionality in relation to RICA, although one could make an argument that RICA should cover it, is interception of data on a bulk basis, or what's known as bulk signals intelligence collection. So in other words, the collection of data at scale on an untargeted basis. So in other words, where discriminators or selectors aren't being used in order to narrow down the data that is being collected. So data is being collected on an untargeted basis, and there was no law actually spelling out or empowering the state security agency in this case to collect bulk data. And this was a long-standing problem that Cabinet had been aware of for many, many years, because there was a commission of inquiry that had happened in the wake of the abuses of the bulk data capabilities of the then National Intelligence Agency, as far back as 2008, which had found that it was inappropriate and most likely unconstitutional that the body inside the State Security Agency that undertakes bulk data collection for intelligence purposes, the National Communications Center, was effectively unregulated by law, because bulk data collection was not a power that was enabled by RICA or any other law for that matter. The State Security Agency argued that the 94 Strategic Intelligence Act gave them the powers to use whatever investigative procedures were necessary to conduct strategic intelligence or collect data for the purposes of strategic intelligence. And usually bulk data is collected for strategic intelligence purposes because it's a form of intelligence that is forward-looking, and it's attempting to quantify the unknowns when it comes to national security threats to a particular country. So because intelligence agencies have very few investigatory powers outside the borders of their own country, it's often been argued that they need to seize on and use whatever few powers they have. And bulk data collection is one of those. So there's always been a justification that's been put forward by intelligence agencies that untargeted bulk data collection is justifiable outside the borders of your own country. And the Constitutional Court although it's still not entirely clear, the Constitutional Court seemed to recognize that signals intelligence collection at scale and in bulk was a legitimate intelligence method. That's a hugely controversial legal issue all on its own.
Yeah.
But it seemed to proceed from that assumption because the sixth area of unconstitutionality that it pointed out was the fact that there was no law governing bulk data collection.
And as far as I understand it, the Constitutional Court, essentially said to the executive, you need to go back to the drawing board and rethink our surveillance laws, at least in terms of, what RICA had done wrong. And from what I am hearing is that because that hasn't been done yet, does RICA still, does it still exist as the operating surveillance law in the country? Or has it been replaced by amendments currently while we're still waiting for this new drafting?
It's very unclear, and greater legal minds than mine, I'm sure, will be able to give you an answer on that particular question. The government doesn't seem to think, for instance, that they have the powers to appoint a RICA judge because the procedure for the appointment still hasn't been finalized. And in fact, one of the things that they had suggested in the still problematic RICA amendment bill, and we can go into some of the problems with that shortly, but one of the things that they'd suggested, which is one of the less problematic features of the bill, was that the RICA judge should be appointed with the concurrence of the Chief Justice. Now, my understanding of the legal meaning of with the concurrence is that it means that the Chief Justice has to agree to that particular appointment, which seemed to remove the problem of non-independence of the judge. Yeah. But because that amendment hasn't been passed into law, they haven't appointed a RICA judge. So effectively, the system is now, as we speak, dysfunctional, because there is no sitting RICA judge that is approving interception directions. So I think, in effect, certainly that aspect of RICA, because there's many other aspects like SIM card registration, as you've mentioned, and what have you, that aspect of RICA, where interception directions are being applied for by intelligence agencies, the judge approves them, and then they go off and then they do their interceptions, appears to have ground to a halt.
And so, okay, so you mentioned the bill and that there are still problematic areas in it. Do you want to maybe just mention a few?
Yes, sure. And I was part of the public hearings into the RICA amendment bill. So I guess you could say I had a bit of a ringside seat into the discussions and subsequently the debates around the bill. And it wasn't a satisfactory process because what we found was that the Department of Justice adopted an inappropriately minimalistic approach towards the amendments. Now, let's go back some years, because if we do, we will have learned that the Department of Justice has for many years now been promising a review of RICA because they recognize the fact that technologies have moved on. And the main method of interception of communications envisaged by RICA which is what's known in the US as lawful interception, or wiretapping, even more colloquially, is a method of communications interception that has to an extent been overtaken by events. People don't really communicate that more by, making phone calls that can then be intercepted by a third, a state body that has been set up specifically for that purpose. We have the Office for Interception Centers that does that, for instance. So it was clear that RICA as a whole needed to be revised, but they haven't revised RICA as a whole. So as a result of that, they tried to plug gaps in RICA and confine themselves only to what the Constitutional Court had pointed out. And that was hugely problematic because they were doing those amendments in the absence of a policy, a thorough think through of what needed to be changed, on a root and branch basis when it came to RICA. So one of the things that the RICA amendments failed to address completely, despite the fact that they recognize that it's a burning issue, is the fact that there's an entirely separate process that can be used in order to intercept people's communications data. And that is through Section 205 of the Criminal Procedures Act, which uses a far lower standard than RICA does for collecting communication data. And that a judge merely needs to be satisfied that the obtaining of the data through a Section 205 is relevant to a case. And as a result of that, it's become the go-to method of interception of communication, albeit just communication data, by intelligence and law enforcement agencies because they can just obtain so much data so easily. That was the first problem. The second problem was that user notification was limited inappropriately because the intelligence agencies can delay notification to surveillance subjects indefinitely if the matter concerns national security. And this is hugely problematic because all the agencies need to do is say national security, and then communication subjects don't get informed for an indefinite period of time. And the definition of national security that South Africa has in the General Intelligence Laws Amendment Act is not bad. It's not the worst in the world. There are some problem areas here and there, but in the greater scheme of things, I can tell you it's a lot better than the operating the understanding not codified into any piece of legislation that people operate with in the UK, for instance. It's a lot better. But
I suppose one of the things with national security, I think that's just popped into my head now. There's a definition of it as we see it in any sort of legislation, but then there's the use of it maybe to obtain authority to do something that maybe had nothing to do with national security in the first place. Often people, maybe I'm just thinking too much from a Hollywood perspective or something like that, but it seems like national security often seems to be the excuse for everything.
Absolutely, yes. And, governments have a vested interest in keeping the definition of national security as elastic and porous as possible in order to justify doing everything about anything. And we're seeing this play out, in the US, for instance, where trade tariffs are now being shoehorned into the US's definition of national security. We're not that bad, I must say. And the reason why we're not that bad is because there was a civil society pushback against the broad draft definition of national security. Be that as it may, we still don't want a situation where subjects of surveillance are potentially never, ever notified on national security grounds. So that was a problem. the Department of Justice put forward a highly problematic way of solving the ex parte problem, which actually didn't solve it at all, which was to introduce a review judge to review decisions that were taken by the presiding judge, the interception judge, if you like. Now, to my mind, that this didn't solve the ex parte problem, because both the sitting judge and the review judge still takes decisions based on the same one-sided information.
Yeah.
So it doesn't even out the disparity between the intelligence agencies on the one hand and surveillance subjects on the other hand. And certainly what I argued for, which the department was not keen on, was the introduction of a special advocate into the process that could act as a privacy advocate, if you like, or someone who would represent the interests of the surveillance subjects in the subject's absence. Necessarily so, because obviously they shouldn't know that interception of their communications is being contemplated until an investigation reaches a non-sensitive stage. So this, for me, was very problematic, because a special advocate, which has been used not necessarily in the context of interception of communications internationally, but in the context of national security cases, like some of the Guantanamo Bay cases, where people have been rendered and held in detention indefinitely for being terrorism suspects. In those kinds of cases, special advocates have been used where they've gone in, they've been given full, unmediated access to the files that have, informed the decisions of the intelligence agencies, and they have pushed back, if you like, and made arguments and contested the bases for these kinds of renditions. And the public advocate system has actually worked very well, because these people are security cleared. So in other words, they don't pose a threat to the security of the entire process. And this was one of the concerns, I think, both on the part of Parliament and the Department of Justice, that introducing another player into the circle of secrecy that is interception of communications would threaten the process. No, that's not necessarily the case at all. But the department was of the feeling that a special advocate is a novel idea in South African law. There's no precedent. And as a result of that, they didn't want to set about setting the precedent now through RICA, but they wanted to conduct research and to consider it fully. And as a result of that, they proposed the review judge. So now the president has slapped them down because he has refused to sign RICA into law, and that is one of the flaws that he's pointed out. So I think these are some of the major problems, weaknesses with RICA. The RICA Amendment Bill, certainly.
Of course. And so you've mentioned now that the president doesn't want to sign it because he doesn't see it as being able to stand constitutional muster. And you mentioned throughout when you were talking about the bill and also the previous act, this idea of data. And I haven't necessarily prepared you for this question, but it was just something that's come up in my head. We're dealing a lot with not only surveillance technology, but we're also looking at the regulation of social media. And so, I mean, obviously we still take phone calls and we still send SMSs and that kind of data, I think was what RICA was envisioning when it was talking about, intercepting communications. But communications now has become a whole other, monster, especially when you consider social media. Data was, scraped in the UK and in the US from social media to effectively target market people from a election campaign point of view. With the Trump elections in 2016, Trump campaign in 2016, and then obviously the Brexit one in the UK. And so, from your understanding, when they talk about data in these legislations or regulations, does it incorporate this idea of metadata online, or is it still kind of outdated as far as you're aware?
RICA is very much a voice law. And, if one considers the legal pedigree, if you like, of this kind of law, it very much came from the days of wiretapping. So, in other words, a pre-data form of interception of communications. However, wiretapping laws were updated in the US. So there was something called the CALEA Act, which is Communications Assistance for Law Enforcement Act, which attempted to upgrade the old analog wiretapping laws to the digital era, and to ensure that wiretapping covered digital online communications. Now, my understanding of RICA is that it does cover analog and digital communications, because if one looks at the definition of interception of communication, it logically would cover all forms of communication, analog and digital, that are capable of being intercepted. However, my understanding of how RICA has been operationalized is that because of the complexities of internet surveillance, that aspect of RICA was never fully operationalized. So to a large extent, it's remained in practice a voice-related law, where it's used to intercept people's phone calls that they make, that diminishing number of people who still make phone calls, grannies and grandpas who still make phone calls. It's their communications that will be particularly vulnerable to interception, and people who still use SMSs. So I think it's been more a practical consideration than a legal consideration that RICA hasn't really been fully extended to digital communications. But having said that, even the best interception, or some may say the worst interception of communications law, hasn't been able to crack the problem of intercepting data that is end-to-end encrypted. I'm saying that perhaps that would qualify as being a bad law, because there is an argument, and I think a solid argument to be made, that end-to-end encryption should not be interfered with. There's an attempt at the moment in the UK, in terms of the Investigatory Powers Act, to require Apple to build a backdoor into its services to enable them to exfiltrate data for intelligence purposes. My personal feeling is that you may land up not solving a number of national security cases. Things may fall through the net, but the danger of compromising end-to-end encryption is far greater in the bigger picture than not being able to collect data, here and there, because it's end-to-end encrypted. So that remains a problem for governments and intelligence agencies, that increasingly data is encrypted. And it's not a problem that I think they've really found a way to solve.
Yeah. And you're speaking about that end-to-end encryption issue at the moment. I'm just seeing emails going through my my inbox at the moment so the Legal Resources Center are part of the International Network of Civil Liberty Organizations, and we're very much going to sign on to a campaign to, go against that move by the UK government with Apple. But Professor, we're very quickly, increasingly running out of time. So I wanted to kind of get your final thoughts on this topic of surveillance law in South Africa. Where to from here? Where do we go? What does we've heard enough, I think, about what government needs to do and what's wrong with the existing laws. How can civil society and ordinary people, go forward now? And what do we need to do to push government to, ensure a safe and secure intelligence legislative framework?
Well, I think certainly South African civil society can do more of what it's already done in the past couple of years, because there's been a lot of highly effective anti-secrecy and anti-surveillance activism that has been undertaken in the country. If one thinks about the Protection of State Information Bill and the way in which two successive presidents haven't dared to sign that into law because of what a hot topic civil society turned it into. So I think more of that organizing where different NGOs and social movements are brought together through a common interest in resisting arbitrary surveillance. I think that is the most important bulwark against surveillance abuses. And then, which is an area I haven't really spoken about that much in this podcast, I think we need to plug into the international debates around bulk surveillance. Because I think that there is a strong argument, legal, political, to be made to outlaw bulk surveillance entirely. And to an extent, actually, this happened in the US in the wake of the Snowden revelations, because the Obama administration decided that bulk telephone data would no longer be collected. So in other words, if they were going to collect telephone data, they would need to use a discriminator, which would make it no longer bulk data collection. And I think that a similar approach can be adopted in relation to bulk surveillance generally, because there's a race to the bottom taking place internationally for digital surveillance capabilities. Everyone wants a piece of the latest digital surveillance tech that's out there, and there's a feeling on the part of governments that if we don't have it and they have it, then we are vulnerable to espionage. And we're seeing a situation where we're also experiencing an ever-expanding definition of national security to include not just threats, but interests, including economic interests. So we are pairing an ever-expanding definition of national security with an ever-expanding a digital surveillance capability, and it really is a marriage made in hell. And it's weaponizing the internet. It's leading to an arms race in cyberspace, where digital surveillance is, if you like, the new weapon of cyber warfare. And we don't respond to an arms race by continuing to buy arms. We respond to it by entering into a multilateral agreement to demilitarize. So I think we need to learn the lessons of the global fight against nuclear arms proliferation, where clearly the world was risking entering into an abyss if we continued proliferating nuclear weapons. And I think we need to think in a similar way about bulk surveillance, because it is the digital era's nuclear weapon. And given the shift to the right in many parts of the world, especially in the US and Europe, and the rise of authoritarian nationalism that doesn't seem to be going away anytime soon, we are seeing a very dangerous development in the world. And I think that the only way that we are going to be able to check it is to start organizing globally to push back against the perceived legitimacy of bulk surveillance powers. We need a multilateral agreement or treaty that demilitarizes the internet.
Well, thank you so much, Professor. I think that was the best answer we could ask for. And I hope everyone listening at home or watching on YouTube heard her effective call to arms for civil society to, take action against bulk surveillance in other forms. Professor, thank you so much for joining us and chatting with me today. It's been a great privilege. And I hope we can work together again on this field.
Thank you.
Thank you for tuning in to Legal Resources Radio. We hope you enjoyed today's episode and gained some valuable insights. If you did, or even if you didn't, please remember to subscribe, rate, and leave a review. Follow us on Twitter, Facebook, and Instagram at Legal Resources SA, or visit our website at lrc.org.za for updates and exclusive content on the incredible work our team is doing. We'll see you on the next episode of Legal Resources Radio. Stay curious, stay inspired, and keep up the good fight.